Hello, everyone. Today we're continuing with part two of Planned Parenthood versus Casey, and we're getting into more of the concurrences and the dissents. So next up is Justice Blackmun concurring in part, concurring in the judgment and dissenting in part. This is the guy who actually wrote the original Roe v. Wade, so let's see what he has to say. I joined parts 1, 2, 3, 5A, 5C, and 6 of the joint opinion of Justices O'Connor, Kennedy, and Souter 3 years ago in Webster versus 3 years ago in Webster versus Reproductive Health Services. Four members of this court appeared poised to cast into darkness the hopes and visions of every woman in this country, who had come to believe that the Constitution guaranteed her the right to reproductive choice. All that remained between the promise of Roe and the darkness of the plurality was a single flickering flame. Decisions since Webster gave little reason to hope that this flame would cast much light. But now, just when so many expected the darkness to fall, the flame has grown bright. I do not understand the significance of today's joint opinion, yet I remain steadfast in my belief that the right to reproductive choice is entitled to the full protection afforded to this Constitution before Webster. And I fear for the darkness as four justices anxiously await the single vote necessary to extinguish the light. Make no mistake, the joint opinion of Justice O'Connor, Kennedy, and Souter is an act of personal courage and constitutional principle. In contrast to previous decisions in which Justices O'Connor and Kennedy postponed a reconsideration of Roe v. Wade, the authors of the joint opinion today join Justice Stevens and me in concluding that the essential holding of Roe v. Wade should be retained and once again affirmed. In brief, 5 members of this court today recognize that the Constitution protects a woman's right to terminate her pregnancy in its early stages. A fervent view of individual liberty and the force of stare decisis have led the court to this conclusion. Today, a majority reaffirms that the Due Process Clause of the 14th Amendment establishes a realm of personal liberty which the government may not enter, a realm whose outer limits cannot be determined by interpretations of the Constitution that focus only on the specific practices of states at the time the 14th Amendment was adopted. Included within this realm of liberty is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. These matters involve the most intimate and personal choices a person may make in a lifetime. Choices central to personal dignity and autonomy are central to the liberty protected by the 14th Amendment. Finally, the court today recognizes that in the case of abortion, the liberty of the woman is at stake in a sense unique to the human condition and so unique to the law. The mother who carries a child to full term is subject to anxieties, to physical constraints, to pain that only she must bear. The court's reaffirmation of Roe's central holding is also based on the force of stare decisis. No erosion of principle going to liberty or personal autonomy has left Roe's central holding a doctrinal remnant. Roe portends no developments at odds with other precedent for the analysis of personal liberty, and no changes of fact have rendered viability more or less appropriate at the point at which the balance of interests tips. Indeed, the court acknowledges that Roe's limitation on state power could not be removed without serious inequity to those who have relied upon it or significant damage to the stability of the society governed by it. In the 19 years since Roe was decided, that case has shaped more than reproductive planning. An entire generation has come of age free to assume Roe's concept of liberty in defining the capacity of women to act in society and to make reproductive decisions. The court understands that, having called the contending sides to end their national division by accepting a common mandate rooted in the Constitution, a decision to overrule Roe would seriously weaken the court's capacity to exercise the judicial power and to function as the Supreme Court of a nation dedicated to the rule of law. What has happened today should serve as a model for future justices and a warning to all who have tried to turn this court into yet another political branch. In striking down the Pennsylvania statute's spousal notification requirement, the court has established a framework for evaluating abortion regulations that responds to the social context of women facing issues of reproductive choice. In determining the burden imposed by the challenged regulation, the court inquires whether the regulation's purpose or effect is to place a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. The court reaffirms, the proper focus of constitutional inquiry is the group for whom the law is a restriction, not the group for whom the law is irrelevant. Looking at this group, the court inquires, based on expert testimony, empirical studies, and common sense, whether, in a large fraction of the cases in which the restriction is relevant, it will operate as a substantial obstacle to a woman's choice to undergo an abortion. A statute with this purpose is invalid because the means chosen by the state to further the interest in potential life must be calculated to inform the woman's free choice, not hinder it. And in applying its test, the court remains sensitive to the unique role of women in the decision-making process. Whatever may have been the practice when the 14th Amendment was adopted, the court observes, women do not lose their constitutionally protected liberty when they marry. The Constitution protects all individuals, male or female, married or unmarried, from the abuse of governmental power, even where that power is employed for the supposed benefit of a member of the individual's family. Lastly, while I believe that the joint opinion errs in failing to invalidate the other regulations, I am pleased that the joint opinion has not ruled out the possibility that these regulations may be shown to impose an unconstitutional burden. The joint opinion makes clear that its specific holdings are based on the insufficiency of the record before it. I am confident that in the future evidence will be produced to show that in a large fraction of the cases in which these regulations are relevant, they will operate as a substantial obstacle to a woman's choice to undergo an abortion. Today, no less than yesterday, the Constitution and decisions of this court require that a state's abortion restrictions be subjected to the strictest judicial scrutiny. Our precedents and the joint opinions principles require us to subject all non-de minimis abortion regulations to strict scrutiny. Under this standard, the Pennsylvania statute's provisions requiring content-based counseling, a 24-hour delay, informed parental consent, and reporting of abortion-related information must be invalidated. The court today reaffirms the long-recognized rights of the privacy and bodily integrity. As early as 1891, the court held, no right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others. Throughout this century, this court also has held that the fundamental right of privacy protects citizens against governmental intrusion in such intimate family matters as procreation, child-rearing, marriage, and contraceptive choice. These cases embody the principle that personal decisions that profoundly affect bodily integrity, identity, and destiny should be largely beyond the reach of government. In Roe v. Wade, this court correctly applied these principles to a woman's right to choose abortion. State restrictions on abortion violate a woman's right of privacy in two ways. First, compelled continuation of a pregnancy infringes upon a woman's right to bodily integrity by imposing substantial physical intrusions and significant risks of physical harm. During pregnancy, women experience dramatic physical changes and a wide range of health consequences. Labor and delivery pose additional health risks and physical demands. In short, restrictive abortion laws force women to endure physical invasions far more substantial than those this court has held to violate the constitutional principle of bodily integrity in other contexts. Further, when the state restricts a woman's right to terminate her pregnancy, it deprives a woman of the right to make her own decision about reproduction and family planning, critical life choices that this court long has deemed central to the right to privacy. The decision to terminate or continue a pregnancy has no less an impact on a woman's life than decisions about contraception or marriage. Because motherhood has a dramatic impact on a woman's educational prospects, employment opportunities, and self-determination, restrictive abortion laws deprive her of basic control over her life. For these reasons, the decision whether or not to beget or bear a child lies at the very heart of this cluster of constitutionally protected choices. A state's restriction on a woman's right to terminate her pregnancy also implicate constitutional guarantees of gender equality. State restrictions on abortion compel women to continue pregnancies they otherwise might terminate. By restricting the right to terminate pregnancies, the state conscripts women's bodies into its service, forcing women to continue their pregnancies, suffer the pains of childbirth, and in most instances provide years of maternal care. The state does not compensate women for their services. Instead, it assumes that they owe this duty as a matter of course. This assumption that women can simply be forced to accept the natural status and incidence of motherhood appears to rest upon a conception of women's role that has triggered the protection of the Equal Protection Clause. The joint opinion recognizes that these assumptions about women's place in society are no longer consistent with our understanding of the family, the individual, or the Constitution. The court has held that limitations on the right of privacy are permissible only if they survive strict constitutional scrutiny. That is, only if the governmental entity imposing the restriction can demonstrate that the limitation is both necessary and narrowly tailored to serve a compelling governmental interest. We have applied this principle specifically in the context of abortion regulations. Roe implemented these principles through a framework that was designed to ensure that the woman's right to choose not become so subordinate to the state's interest in promoting fetal life that her choice exists in theory but not in fact. Roe identified two relevant state interests: an interest in preserving and protecting the health of the pregnant woman, and an interest in protecting the potentiality of human life. With respect to the state's interest in the health of the mother, the compelling point is at approximately the end of the first trimester, because it is at that point that the mortality rate in abortion approaches that in childbirth. With respect to the state's interest in potential life, the compelling point is at viability, because it is at that point that the fetus presumably has the capacity of meaningful life outside the mother's womb. In order to fulfill the requirement of narrow tailoring, the state is obligated to make a reasonable effort to limit the effect of its regulations to the period in the trimester during which its health interest will be furthered. In my view, application of this analytical framework is no less warranted than when it was approved by 7 members of this court in Roe. Strict scrutiny of state limitations on reproductive choice still offers the most secure protection of the woman's right to make her own reproductive decisions, free from state coercion. No majority of this court has ever agreed upon an alternative approach. The factual premises of the trimester framework have not been undermined, and the Roe framework is far more administrable and far less manipulable than the undue burden standard adopted by the joint opinion. Nonetheless, 3 criticisms of the trimester framework continue to be uttered. First, the trimester framework is attacked because its key elements do not appear in the text of the Constitution. My response to this attack remains the same as it was in Webster. Were this a true concern, we would have to abandon most of our constitutional jurisprudence. The critical elements of countless constitutional doctrines nowhere appear in the Constitution's text. The Constitution makes no mention, for example, of the First Amendment's actual malice standard for proving certain libels. Similarly, the Constitution makes no mention of the rational basis test or the specific verbal formulations of intermediate and strict scrutiny by which this court evaluates claims under the Equal Protection Clause. The reason is simple. Like the Roe framework, these tests or standards are not and do not purport to be rights protected by the Constitution. Rather, they are judge-made methods for evaluating and measuring the strength and scope of constitutional rights, or for balancing the constitutional rights of individuals against the competing interests of government. The second criticism is that the framework more closely resembles a regulatory code than a body of constitutional doctrine. Again, my answer remains the same as in Webster. If this were a true and genuine concern, we would have to abandon vast areas of our constitutional jurisprudence. Are the distinctions entailed in the trimester framework any finer or more regulatory than the distinctions we have often drawn in our First Amendment jurisprudence, where, for example, we have held that a release time program permitting public school students to leave school grounds during school hours to receive religious instruction does not violate the Establishment Clause, even though a release time program permitting religious instruction on school grounds does violate the clause. Similarly, in a Sixth Amendment case, the court held that although an overnight ban on attorney-client communication violated the constitutionally guaranteed right to counsel, that right was not violated when a trial judge separated a defendant from his lawyer during a 15-minute recess after the defendant's direct testimony. The numerous constitutional doctrines result in narrow differentiations between similar circumstances. That numerous constitutional doctrines result in narrow differentiations between similar circumstances does not mean that this court had abandoned adjudication in favor of regulation. The final and more genuine criticism of the trimester framework is that it fails to find the state's interest in potential human life compelling throughout pregnancy. No member of this court, nor for that matter the Solicitor General, has ever questioned our holding in Roe that an abortion is not the termination of life entitled to 14th Amendment protection. Accordingly, a state's interest in protecting fetal life is not grounded in the Constitution, nor consistent with our Establishment Clause can it be a theological or sectarian interest. It is instead a legitimate interest grounded in humanitarian or pragmatic concerns. But while a state has legitimate interests from the outset of the pregnancy in protecting the health of the woman and the life of the fetus that may become a child, legitimate interests are not enough. To overcome the burden of strict scrutiny, the interests must be compelling. The question then is how best to accommodate the state's interest in potential human life with the constitutional liberties of pregnant women. Again, I stand by my views I expressed in Webster. I remain convinced, as 6 other members of this court 16 years ago were convinced, that the Roe framework and the viability standard in particular, fairly, sensibly, and effectively, functions to safeguard the constitutional liberties of pregnant women while recognizing and accommodating the state's interest in potential human life. The viability line reflects the biological facts and truths of fetal development. It marks that threshold moment prior to which a fetus cannot survive separate from the woman and cannot reasonably and objectively be regarded as a subject of rights or interests distinct from or paramount to those of the pregnant woman. At the same time, the viability standard takes account of the undeniable fact that as the fetus evolves into its postnatal form and as it loses its dependence on the uterine environment, the state's interest in the fetus's potential human life and in fostering a regard for human life in general becomes compelling. As a practical matter, because viability follows quickening, the point at which a woman feels movement in her womb, and because viability occurs no earlier than 23 weeks gestational age, it establishes an easily applicable standard for regulating abortion while providing a pregnant woman ample time to exercise her fundamental right with her responsible physician to terminate her pregnancy. Roe's trimester framework does not ignore the state's interest in prenatal life. Like Justice Stevens, I agree that the states may take steps to ensure that a woman's choice is thoughtful and informed, and that states are free to enact laws to provide a reasonable framework for a woman to make a decision that has such profound and lasting meaning. Serious questions arise when a state attempts to persuade the woman to choose childbirth over abortion. Decisional autonomy must limit the state's power to inject into a woman's most personal deliberations its own views of what is best. The state may promote its preferences by funding childbirth, by creating and maintaining alternatives to abortion, and by espousing the virtues of family, but it must respect the individual's freedom to make such judgments. As the joint opinion recognizes, the means chosen by the state to further the interest in potential life must be calculated to inform the woman's free choice, not hinder it. In sum, Roe's requirement of strict scrutiny as implemented through a trimester framework should not be disturbed. No other approach has gained a majority, and no other is more protective of the woman's fundamental right. Lastly, no other approach properly accommodates the woman's constitutional right with the state's legitimate interests. Application of the strict scrutiny standard results in the invalidation of all the challenged provisions. Indeed, as this court has invalidated virtually identical provisions in prior cases, stare decisis requires that we again strike them down. This court has upheld informed and written consent requirements only where the state has demonstrated that they genuinely further important health-related state concerns. A state may not, under the guise of securing informed consent, require the delivery of information designed to influence the woman's informed choice between abortion or childbirth. Rigid requirements that a specific body of information be imparted to a woman in all cases, regardless of the needs of the patient, improperly intrude upon the discretion of the pregnant woman's physician and thereby impose an undesired and uncomfortable straitjacket. Measured against these principles, some aspects of the Pennsylvania informed consent scheme are unconstitutional. While it is unobjectionable for the Commonwealth to require that the patient be informed of the nature of the procedure, the health risks of the abortion and of childbirth, and the probable gestational age of the unborn child, compare with Akron, compare Pennsylvania constitutional statute, subsections 3205A 1 through 3, with Akron. I remain unconvinced that there is a vital state need for insisting that the information be provided by a physician rather than a counselor. The district court found that the physician-only requirement necessarily would increase costs to the plaintiff clinics, costs that undoubtedly would be passed on to patients. And because trained women counselors are often more understanding than physicians and generally have more time to spend with patients, the physician-only disclosure requirement is not narrowly tailored to serve the Commonwealth's interest in protecting maternal health. Sections 3205A2 1 through 3 of the Act further requires that the physician or a qualified non-physician inform the woman that printed materials are available from the Commonwealth that describe the fetus and provide information about medical assistance for childbirth, information about child support from the father, and a list of agencies offering adoption and other services as alternatives to abortion. Thornburg invalidated biased patient counseling requirements virtually identical to the one at issue here. What we said to those requirements fully applies in these cases. The listing of agencies in the printed Pennsylvania form presents serious problems. It contains names of agencies that well may be out of step with the needs of the particular woman and thus places the physician in an awkward position and infringes upon his or her professional responsibilities. Forcing the physician or counselor to present the materials and the list to the woman makes him or her, in effect, an agent of the state in treating the woman and places his or her imprimatur upon both the materials and the list. All this is, or comes close to being, state medicine imposed upon the woman, not the professional medicine guidance she seeks, and it officially structures as it obviously was intended to do, the dialogue between the woman and her physician. The requirements that the woman be advised that medical assistance benefits may be available and that the father is responsible for financial assistance in the support of the child similarly are poorly disguised elements of discouragement for the abortion decision. Much of this, for many patients, would be irrelevant and inappropriate. For a patient with a life-threatening pregnancy, the information in its very rendition may be cruel as well as destructive of the physician-patient relationship. And as any experienced social worker or other counselor knows, theoretical financial responsibility often does not equate with fulfillment. Under the guise of informed consent, the Act requires the dissemination of information that is not relevant to such consent, and thus it advances no legitimate state interest. This type of compelled information is the antithesis of informed consent, and goes far beyond merely describing the general subject matter relevant to the woman's decision. That the Commonwealth does not, and surely would not, compel similar disclosure of every possible peril of necessary surgery or of simple vaccination reveals the anti-abortion character of the statute and its real purpose. The 24-hour waiting period following the provision of the foregoing information is also clearly unconstitutional. The district court found that the mandatory 24-hour delay could lead to delays in excess of 24 hours, thus increasing health risks and that it would require 2 visits to the abortion provider, thereby increasing travel time, exposure to further harassment, and financial cost. Finally, the district court found that the requirement would pose especially significant burdens on women living in rural areas and those women that have difficulty explaining their whereabouts. In Akron, this court invalidated a similarly arbitrary or inflexible waiting period because, as here, it furthered no legitimate state interest. As Justice Stevens insightfully concludes, the mandatory delay rests either on outmoded or unacceptable assumptions about the decision-making capacity of women or the belief that the decision to terminate the pregnancy is presumptively wrong. The requirement that women consider this obvious and slanted information for an additional 24 hours contained in these provisions will only influence the woman's decision in improper ways. The vast majority of women will know this information. Of the few that do not, it is less likely that their minds will be changed by this information than it will be either by the realization that the state opposes their choice or the need once again to endure abuse and harassment on return to the clinic. Except in the case of a medical emergency, subsection 3206 requires a physician to obtain the informed consent of a parent or a guardian before performing an abortion on an unemancipated minor or an incompetent woman. Based on evidence in the record, the district court concluded that in order to fulfill the informed consent requirement, generally accepted medical principles would require an in-person visit by the parent to the facility. Although the court has recognized that the state has somewhat broader authority to regulate the activities of children than of adults, the state nevertheless must demonstrate that there is a significant state interest in conditioning an abortion that is not present in the case of an adult. The requirement of an in-person visit would carry with it the risk of a delay of several days or possibly weeks, even where the parent is willing to consent. While the state has an interest in encouraging parental involvement in the minor's abortion decisions, subsection 3206 is not narrowly drawn to serve that interest. Finally, the Pennsylvania statute requires every facility performing abortions to report its activities to the Commonwealth. Pennsylvania contends that this requirement is valid under Danforth, in which this court held that record-keeping and reporting requirements that are reasonably directed to the preservation of maternal health and that properly respect a patient's confidentiality are permissible. The Commonwealth attempts to justify its required reports on the ground that the public has a right to know how its tax dollars are spent. A regulation designed to inform the public about public expenditures does not further the Commonwealth's interest in protecting maternal health. Accordingly, such a regulation cannot justify a legally significant burden on a woman's right to obtain an abortion. The confidential reports concerning the identities and medical judgment of physicians involved in abortions at first glance may seem valid, given the Commonwealth's interest in maternal health and enforcement of the Act. The district court found, however, that notwithstanding the confidentiality protections, many physicians, particularly those who have previously discontinued performing abortions because of harassment, would refuse to refer patients to abortion clinics if their names were to appear on these reports. The Commonwealth has failed to show that the name of the referring physician either adds to the pool of scientific knowledge concerning abortion or is reasonably related to the Commonwealth's interest in maternal health. I therefore agree with the district court's conclusion that the confidential reporting requirements are unconstitutional insofar as they require the name of the referring physician and the basis for his or her medical judgment. In sum, I would affirm the judgment in number 91-902 and reverse the judgment in number 91-744 and remand the cases for further proceedings. At long last, the Chief Justice and those who have joined him admit it. Gone are the contentions that the issue need not be or has not been considered. There, on the first page for all to see, is what was expected. We believe that Roe was wrongly decided and that it can and should be overruled consistently with our traditional approach to stare decisis in constitutional cases. If there is much reason to applaud the advances made by the joint opinion today, there is far more to fear from the Chief Justice's opinion. The Chief Justice's criticism of Roe follows from his stunted conception of individual liberty. While recognizing that the Due Process Clause protects more than simple physical liberty, he then goes on to construe this court's personal liberty cases as establishing only a laundry list of particular rights rather than a principled account of how these particular rights are grounded in a more general right of privacy. This constricted view is reinforced by the Chief Justice's exclusive reliance on tradition as a source of fundamental rights. He argues that the record in favor of a right to abortion is no stronger than the record in Michael H. v. Gerald D., where the plurality found no fundamental right to visitation privileges by an adulterous father, or in Bowers v. Hardwick, side note, Bowers v. Hardwick's been overruled, where the court found no fundamental right to engage in homosexual sodomy, or in a case involving the firing of a gun into another person's body. Wait, what? Where the court found no fundamental right to engage in homosexual sodomy or in a case involving the firing of a gun into another person's body. In the Chief Justice's world, a woman considering whether to terminate a pregnancy is entitled to no more protection than adulterers, murderers, and so-called sexual deviants. Given the Chief Justice's exclusive reliance on tradition, people using contraceptives seem the next likely candidate for his list of outcasts. Even more shocking than the Chief Justice's cramped notion of individual liberty is his complete omission of any discussion of the effects that compelled childbirth and motherhood have on women's lives. The only expression of concern is whether women's health is purely instrumental or for the Chief Justice, only women's psychological health is a concern, and only to the extent that he assumes that every woman who decides to have an abortion does so without serious consideration of the moral implications of her decision. In short, the Chief Justice's view of the state's compelling interest in maternal health has less to do with health than it does with compelling women to be maternal. Nor does the Chief Justice give any serious consideration to the doctrine of stare decisis. For the Chief Justice, the facts that gave rise to Roe are surprisingly simple. Women become pregnant. There is a point somewhere, depending on medical technology, where a fetus becomes viable and women give birth to children. This characterization of the issue thus allows the Chief Justice quickly to discard the joint opinions reliance argument by asserting that reproductive planning could take virtually immediate account of a decision overruling Roe. The Chief Justice's narrow conception of individual liberty and stare decisis leads him to propose the same standard of review proposed by the plurality in Webster. States may regulate abortion procedures in ways rationally related to a legitimate state interest. The Chief Justice then further weakens the test by providing an insurmountable requirement for facial challenges. Petitioners must show that no set of circumstances exists under which the provision would be valid. In short, in his view, petitioners must prove that the statute cannot constitutionally be applied to anyone. Finally, in applying his standard to the spousal notification provision, the Chief Justice contends that the record lacks any hard evidence to support the joint opinion's contention that a large fraction of women who prefer not to notify their husbands involve situations of battered women and unreported spousal assault. Yet, throughout the explication of his standard, the Chief Justice never explains what hard evidence is, how large a fraction is required, and how a battered woman is supposed to pursue an as-applied challenge. Under his standard, states can ban abortion if that ban is rationally related to a legitimate state interest, a standard which the United States calls deferential but not toothless. Yet when pressed at oral argument to describe the teeth, the best protection that the Solicitor General could offer to women was that a prohibition enforced by criminal penalties with no exception for the life of the mother could raise various serious questions. Perhaps the Solicitor General offered the failure to include an exemption for the life of the mother that would be arbitrary and capricious, if, as the Chief Justice contends, the undue burden test is made out of whole cloth. The so-called arbitrary and capricious limit is the Solicitor General's new clothes. Even if it is somehow irrational for a state to require a woman to risk her life for her child, what protection is offered to women who become pregnant through rape or incest? Is there anything arbitrary or capricious about a state's prohibiting the sins of the father from being visited upon his offspring? But we are reassured there is always the protection of the democratic process. While there is much to be praised about our democracy, our country since its founding has recognized that there are certain fundamental liberties that are not to be left to the whims of an election. A woman's right to reproductive choice is one of those fundamental liberties. Accordingly, that liberty need not seek refuge at the ballot box. In one sense, the court's approach is worlds apart from that of the Chief Justice and Justice Scalia. And yet, in another sense, the distance between the two approaches is short. The distance is but a single vote. I am 83 years old. I cannot remain on this court forever, and when I do step down, the confirmation process for my successor may focus on the issue before us today. That, I regret, may be exactly where the choice between the two worlds will be made. Chief Justice Rehnquist, with whom Justice White, Justice Scalia, and Justice Thomas joined, concurring in the judgment in part and dissenting in part. The joint opinion, following its newly minted variation on stare decisis, retains the outer shell of Roe v. Wade, but beats a wholesale retreat from the substance of that case. We believe that Roe was wrongly decided and that it can and should be overruled consistently with our traditional approach to stare decisis in constitutional cases. We would adopt the approach of the plurality in Webster v. Reproductive Services and uphold the challenge provisions of the Pennsylvania statute in their entirety. In ruling on this litigation below, the Court of Appeals for the Third Circuit first observed that this appeal does not directly implicate Roe. This case involves the regulation of abortions rather than their outright prohibition. Accordingly, the court directed its attention to the question of the standard of review for abortion regulations. In attempting to settle on the correct standard, however, the court confronted the confused state of this court's abortion jurisprudence. After considering the several opinions in Webster v. Reproductive Health Services and Hodgson v. Minnesota, the Court of Appeals concluded that Justice O'Connor's undue burden test was controlling, and that was the narrowest ground on which we had upheld recent abortion regulations. When a fragmented court decides a case and no single rationale explaining the result enjoys the assent of 5 justices, the holding of the court may be viewed as that position taken by those members who concurred in the judgments on the narrowest grounds. Applying this standard, the Court of Appeals upheld all of the challenged regulations except the one requiring a woman to notify her spouse of an intended abortion. In arguing that this court should invalidate each of the provisions at issue, petitioners insist that we reaffirm our decisions in Roe v. Wade, in which we held unconstitutional a Texas statute making it a crime to procure an abortion except to save the life of the mother. We agree with the Court of Appeals that our decision in Roe is not directly implicated by the Pennsylvania statute, which does not prohibit but simply regulates abortion. But as the Court of Appeals found, the state of our post-Roe decision law dealing with the regulation of abortion is confusing and uncertain, indicating that a reexamination of that line of cases is in order. Unfortunately, for those who must apply this court's decisions, the reexamination undertaken today leaves the court no less divided than beforehand. Although they reject the trimester framework that formed the underpinning of Roe, Justice O'Connor, Kennedy, and Souter adopted a revised undue burden standard to analyze the challenged regulations. We conclude, however, that such an outcome is an unjustified constitutional compromise, one which leaves the court in a position to closely scrutinize all types of abortion regulations, despite the fact that it lacks the power to do so under the Constitution. In Roe, the court opined that the state does have an important and legitimate interest in preserving and protecting the health of the pregnant woman, and that it has still another important and legitimate interest in protecting the potentiality of human life. In the companion case of Doe v. Bolton, the court referred to its conclusion in Roe that a pregnant woman does not have an absolute constitutional right to an abortion on her demand. But while the language and holding of these cases appeared to leave states free to regulate abortion procedures in a variety of ways, later decisions based on them have found considerably less latitude for such regulations that might have been expected. For example, after Roe, many states have sought to protect their young citizens by requiring that a minor seeking an abortion involve her parents in the decision. Some states have simply required notification of the parents, while others have required a minor to obtain the consent of her parents. In a number of decisions, however, the court has substantially limited the states in their ability to impose such requirements. With regard to parental notice requirements, we initially held that a state could require a minor to notify her parents before proceeding with an abortion. Recently, however, we indicated that a state's ability to impose a notice requirement actually depends on whether it requires notice of one or both parents. We concluded that although the Constitution might allow a state to demand that notice be given to one parent prior to an abortion, it may not require that similar notice be given to 2 parents, unless the state incorporates a judicial bypass procedure in that 2-parent requirement. We have treated parental consent provisions even more harshly. 3 years after Roe, we invalidated a Missouri regulation requiring that an unmarried woman under the age of 18 obtain the consent of one of her parents before proceeding with an abortion. We held that our abortion jurisprudence prohibited the state from imposing such a blanket provision requiring the consent of a parent. In Bilotti v. Baird, the court struck down a similar Massachusetts parental consent statute. A majority of the court indicated, however, that a state could constitutionally require parental consent if it alternatively allowed a pregnant minor to obtain an abortion without parental consent by showing either that she was mature enough to make her own decision or that the abortion would be in her best interest. In light of Bilotti, we have upheld one parental consent regulation which incorporated a judicial bypass option we viewed as sufficient. Let me back up. In light of Bilotti, we have upheld one parental consent regulation, which incorporated a judicial bypass option we viewed as sufficient. See Planned Parenthood Association of Kansas City, Missouri, Incorporated versus Ashcroft. But have invalidated another because of our belief that the judicial procedure did not satisfy the dictates of Bilotti. We have never had occasion, as we have in the parental notice context, to further parse our parental consent jurisprudence into one parent and two parent components. In Roe, the court observed that certain states recognize the right of the father to participate in the abortion decision in certain circumstances, but neither Roe nor Doe involved the assertion of any parental right. The court expressly stated that the case did not disturb the validity of regulations that protected such a right. But 3 years later, in Danforth, the court extended its abortion jurisprudence and held that a state could not require that a woman obtain the consent of her spouse before proceeding with an abortion. States have also regularly tried to ensure that a woman's decision to have an abortion is an informed and well-considered one. In Danforth, we upheld a requirement that a woman sign a consent form prior to her abortion, and observed that it is desirable and imperative that the decision be made with full knowledge of its nature and consequences. Since that case, however, we have twice invalidated state statutes designed to impart such knowledge to a woman seeking an abortion. In Akron, we held unconstitutional a regulation requiring a physician to inform a woman seeking an abortion of the status of her pregnancy, the development of her fetus, the date of possible viability, the complications that could result from an abortion, and the availability of agencies providing assistance and information with respect to adoption and childbirth. More recently, in Thornburg versus American College of Obstetricians and Gynecologists, we struck down a more limited Pennsylvania regulation requiring that a woman be informed of the risks associated with the abortion procedure and the assistance available to her if she decided to proceed with her pregnancy, because we saw the compelled information as the antithesis of informed consent. Even when a state has sought only to provide information that, in our view, was consistent with the Roe framework, we concluded that the state could not require that a physician furnish the information, but instead had to alternatively allow non-physician counselors to provide it. In Akron, as well, we went further and held that a state may not require a physician to wait 24 hours to perform an abortion after receiving the consent of a woman. Although the state sought to ensure that the woman's decision was carefully considered, the court concluded that the Constitution forbade the state to impose any sort of delay. We have not allowed states much leeway to regulate even the actual abortion procedure. Although a state can require that second trimester abortions be performed in outpatient clinics, we concluded in Akron and Ashcroft that a state could not require that such abortions be performed only in hospitals. Despite the fact that Roe expressly allowed regulation after the first trimester in furtherance of maternal health, present medical knowledge, in our view, could not justify such a hospitalization requirement under the trimester framework. And in Danforth, the court held that Missouri could not outlaw the saline and amniocentesis, I butchered that, method of abortion, concluding that the Missouri legislature had failed to appreciate and to consider several significant facts in making its decision. Although Roe allowed state regulation after the point of viability to protect the potential life of the fetus, the court subsequently rejected attempts to regulate in this manner. In Colati v. Franklin, the court struck down a statute that governed the determination of viability. In the process, we made clear that the trimester framework incorporated only one definition of viability, ours, as we forbade states to decide that a certain objective indicator, be it weeks of gestation or fetal weight or any other single factor, should govern the definition of viability. In that same case, we also invalidated a regulation requiring a physician to use the abortion technique offering the best chance for fetal survival when performing post-viability abortions. In Thornburg, the court struck down Pennsylvania's requirement that a second physician be present at post-viability abortions to help preserve the health of the unborn child, on the ground that it did not incorporate a sufficient medical emergency exception. Regulations governing the treatment of aborted fetuses have met a similar fate. In Akron, we invalidated a provision requiring physicians performing abortions to ensure that the remains of the unborn child are disposed of in a humane and sanitary manner. Dissents in these cases expressed the view that the court was expanding upon Roe in imposing ever greater restrictions on the states. See Thornburg versus American College of Obstetricians and Gynecologists, quoting Chief Justice Berger dissenting. The extent to which the court has departed from the limitations expressed in Roe is readily apparent. And also Justice White dissenting. The majority indiscriminately strikes down statutory provisions that in no way contravene the right recognized in Roe. And when confronted with state regulations of this type in past years, the court has become increasingly more divided. The three most recent abortion cases have not commanded a court opinion. See Ohio versus Akron Center for Reproductive Health, Hodgson versus Minnesota, and Webster versus Reproductive Health Services. The task of the Court of Appeals in the present cases was obviously complicated by this confusion and uncertainty. Following Marks v. United States, it concluded that in light of Webster and Hodgson, the strict scrutiny standard enunciated in Roe was no longer applicable and that the undue burden standard adopted by Justice O'Connor was the governing principle. This state of confusion and disagreement warrants re-examination of the fundamental right accorded to a woman's decision to abort a fetus in Roe, with its concomitant requirement that any state regulation of abortion survive strict scrutiny. See Payne v. Texas, observing that re-examination of constitutional decisions is appropriate when those decisions have generated uncertainty and failed to provide clear guidance because correction through legislative action is practically impossible. We have held that a liberty interest protected under the Due Process Clause of the First Amendment will be deemed fundamental if it is implicit in the concept of ordered liberty. 3 years earlier in Snyder v. Massachusetts, we referred to a principle of justice so rooted in the traditions and conscience of our people as to be ranked as fundamental. These expressions are admittedly not precise, but our decisions implementing this notion of fundamental rights do not afford any more elaborate basis on which to base such a classification. In construing the phrase liberty incorporated in the Due Process Clause of the 14th Amendment, we have recognized that its meaning extends beyond freedom from physical restraint. In Pierce v. Society of Sisters, we held that it includes a parent's right to send a child to private school. In Meyer v. Nebraska, we held that it included a right to teach a foreign language in a parochial school. Building on these cases, we have held that the term liberty includes a right to marry, Loving v. Virginia, a right to procreate, Skinner v. Oklahoma, X. Rel. Williamson, and a right to use contraceptives, Griswold v. Connecticut, Eisenstadt v. Baird. But a reading of these opinions makes clear that they do not endorse any all-encompassing right of privacy. In Roe v. Wade, the court recognized a guarantee of personal privacy, which is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. We are now of the view that in terming this right fundamental, the court in Roe read the earlier opinions upon which it based its decision much too broadly. Unlike marriage, procreation, and contraception, abortion involves the purposeful termination of a potential life. The abortion decision must therefore be recognized as sui generis, different in kind from the others that the court has protected under the rubric of personal or family privacy and autonomy. One cannot ignore the fact that a woman is not isolated in her pregnancy, and that the decision to abort necessarily involves the destruction of a fetus. See Michael H. v. Gerald D. To look at the act which is assertedly the subject of a liberty interest in isolation from its effect upon other people is like inquiring whether there is a liberty interest in firing a gun where the case at hand happens to involve its discharge into another person's body. Nor do the historical traditions of the American people support the view that the right to terminate one's pregnancy is fundamental. The common law, which we inherited from England, made abortion after quickening an offense. At the time of the adoption of the 14th Amendment, statutory prohibitions or restrictions on abortion were commonplace. In 1868, at least 28 of the then 37 states and 8 territories had statutes banning or limiting abortion. By the turn of the century, virtually every state had a law prohibiting or restricting abortions on its books. By the middle of the present century, a liberalization trend had set in. But 21 of the restrictive abortion laws in effect in 1868 were still in effect in 1973 when Roe was decided, and an overwhelming majority of the states prohibited abortion unless necessary to preserve the life or health of the mother. Quoting Roe v. Wade, Justice Rehnquist dissenting. On this record, it can scarcely be said that any deeply rooted tradition of relatively unrestricted abortion in our history supported the classification of the right to abortion as fundamental under the Due Process Clause of the 14th Amendment. We think, therefore, both in view of this history and of our decided cases dealing with substantive liberty under the Due Process Clause, that the court was mistaken in Roe when it classified a woman's decision to terminate her pregnancy as a fundamental right that could be abridged only in a manner which withstood strict scrutiny. In so concluding, we repeat the observation made in Bowers v. Hardwick. Nor are we inclined to take a more expansive view of our authority to discover new fundamental rights embedded in the Due Process Clause. The court is most vulnerable and comes nearest to illegitimacy when it deals with judge-made constitutional law, having little or no cognizable roots in the language or design of the Constitution. We believe that the sort of constitutionally imposed abortion code of the type illustrated by our decisions following Roe is inconsistent with the notion of a constitution cast in general terms, as ours is, and usually speaking in general principles, as ours does. The court in Roe reached too far when it analogized the right to abort a fetus to the rights involved in Pierce, Meyer, Loving, and Griswold, and thereby deemed the right to abortion fundamental. The joint opinion of Justice O'Connor, Kennedy, and Souter cannot bring itself to say that Roe was correct as an original matter, but the authors are of the view that the immediate question is not the soundness of Roe's resolution of the issue, but the precedential force that must be accorded to its holding. Instead of claiming that Roe was correct as a matter of original constitutional interpretation, the opinion therefore contains an elaborate discussion of stare decisis. This discussion of the principle of stare decisis appears to be almost entirely dicta, because the joint opinion does not apply that principle in dealing with Roe. Roe decided that a woman had a fundamental right to an abortion. The joint opinion rejects that view. Roe decided that abortion regulations were to be subjected to strict scrutiny and could be justified only in the light of compelling state interest. The joint opinion rejects that view. Roe analyzed abortion regulation under a rigid trimester framework, a framework which had guided this court's decision-making for 19 years. The joint opinion rejects that framework. The stare decisis is defined in Black's Law Dictionary as meaning to abide by or adhere to decided cases. Whatever the central holding of Roe that is left after the joint opinion finishes dissecting it is surely not the result of that principle. While purporting to adhere to precedent, the joint opinion instead revises it. Roe continues to exist, but only in the way a storefront on a Western movie set exists, a mere facade to give the illusion of reality. Decisions following Roe, such as Akron v. Akron Center for Reproductive Health, Incorporated, and Thornburg v. American College of Obstetricians and Gynecologists, are frankly overruled in part under the undue burden standard expounded in the joint opinion. In our view, authentic principles of stare decisis do not require that any portion of the reasoning in Roe be kept intact. Stare decisis is not a universal, inexorable command, especially in cases involving the interpretations of the federal Constitution. Erroneous decisions in such constitutional cases are uniquely durable because correction through legislative action, save for constitutional amendment, is impossible. It is therefore our duty to reconsider constitutional interpretations that depart from a proper understanding of the Constitution. In cases involving the federal Constitution, quoting United States v. Scott, in cases involving the federal Constitution, the court bows to the lessons of experience and the force of better reasoning, recognizing that the process of trial and error, so fruitful in the physical sciences, is appropriate also in the judicial function. Quoting Burnett v. Coronado Oil and Gas, quoting Burnett versus Coronado Oil and Gas Company. By Justice Brandeis and in Smith v. Allred. Our constitutional watch does not cease merely because we have spoken before on an issue. When it becomes clear that a prior constitutional interpretation is unsound, we are obliged to re-examine the question. The joint opinion discusses several stare decisis factors which, it asserts, points towards retaining a portion of Roe. Two of these factors are that the main factual underpinnings of Roe has remained the same, and that its doctrinal foundation is no weaker now than it was in 1973. Of course, what might be called the basic facts which give rise to Roe have remained the same. Women become pregnant. There is a point somewhere, depending on medical technology, where a fetus becomes viable, and women give birth to children. But this is only to say that the same facts which give rise to Roe will continue to give rise to similar cases. It is not a reason in and of itself why those cases must be decided in the same incorrect manner as was the first case to deal with the question. And surely there is no requirement in considering whether to depart from stare decisis in a constitutional case, that a decision be more wrong now than it was at the time it was rendered. If that were true, the most outlandish constitutional decision could survive forever, based simply on the fact that it was no more outlandish later than it was when originally rendered. Nor does the joint opinion faithfully follow this alleged requirement. The opinion frankly concludes that Roe and its progeny were wrong in failing to recognize that the state's interest in maternal health and in the protection of unborn human life exist throughout pregnancy. But there is no indication that these components of Roe are any more incorrect at this juncture than they were at its inception. The joint opinion also points to the reliance interests involved in this context in its effort to explain why precedent must be followed for precedent's sake. Certainly it is true that where reliance is truly at issue, as in the case of judicial decisions that have formed the basis for private decisions, considerations in favor of stare decisis are at their acme. But as the joint opinion apparently agrees, any traditional notion of reliance is not applicable here. The court today cuts back on the protection afforded by Roe, and no one claims that this action defeats any reliance interest in the disavowed trimester framework. Similarly, reliance interests would not be diminished were the court to go further and acknowledge the full error of Roe, as reproductive planning could take virtually immediate account of this action. The joint opinion thus turns to what can only be described as an unconventional and unconvincing notion of reliance, a view based on the surmise that the availability of abortion since Roe has led to 2 decades of economic and social developments that would be undercut if the error of Roe were recognized. The joint opinion's assertion of this fact is undeveloped and totally conclusory. In fact, one cannot be sure to what economic and social developments the opinion is referring. Surely it is dubious to suggest that women have reached their places in society in reliance upon Roe rather than as a result of their determination to obtain higher education and compete with men in the job market and of society's increasing recognition of their ability to fill positions that were previously thought to be reserved only for men. In the end, having failed to put forth any evidence to prove any true reliance, the joint opinion's argument is based solely on generalized assertions about the nation's national psyche, on a belief that the people of this country have grown accustomed to the Roe decision over the last 19 years and have ordered their thinking and living around it. As an initial matter, one might inquire how the joint opinion can view the central holding of Roe as so deeply rooted in our constitutional culture when it so casually uproots and disposes of that same decision's trimester framework. Furthermore, at various points in the past, the same could have been said about this court's erroneous decisions that the Constitution allowed separate but equal treatments of minorities, see Plessy v. Ferguson, or that liberty under the Due Process Clause protected freedom of contract, see Adkins v. Children's Hospital of District of Columbia and Lochner v. New York. The separate but equal doctrine lasted 58 years after Plessy, and Lochner's protection of contractual freedom lasted 32 years. However, the simple fact that a generation or more had grown used to these major decisions did not prevent the court from correcting its errors in those cases, nor should it prevent us from correctly interpreting the Constitution here. Apparently realizing that conventional stare decisis principles do not support its position, the joint opinion advances a belief that retaining a portion of Roe is necessary to project the legitimacy of this court. Because the court must take care to render decisions grounded truly in principle and not simply as political and social compromises, the joint opinion properly declares it to be this court's duty to ignore the public criticism and protest that may arise as a result of a decision. Few would quarrel with this statement, although it may be doubted that members of this court, holding their tenure as they do during constitutional good behavior, are at all likely to be intimidated by such public protests. But the joint opinion goes on to state that when the court resolves the sort of intensely divisive controversy reflected in Roe and those rare comparable cases, its decision is exempt from reconsideration under established principles of stare decisis in constitutional cases. This is so, the joint opinion contends, because in those intensely divisive cases, the court has called the contending sides of a national controversy to end their national division by accepting a common mandate rooted in the Constitution, and must therefore take special care not to be perceived as surrendering to political pressure and continued opposition. This is a truly novel principle, one which is contrary to both the court's historical practice and to the court's traditional willingness to tolerate criticism of its opinions. Under this principle, when the court has ruled on a divisive issue, it is apparently prevented from overruling that decision for the sole reason that it was incorrect, unless opposition to the original decision has died away. Now, the first difficulty with this principle lies in its assumption that cases that are intensely divisive can be readily distinguished from those that are not. The question of whether a particular issue is intensely divisive enough to qualify for special protection is entirely subjective and dependent on the individual assumptions of the members of this court. In addition, because the court's duty is to ignore public opinion and criticism on issues that come before it, its members are in perhaps the worst position to judge whether a decision divides the nation deeply enough to justify such uncommon protection. Although many of the court's decisions divide the populace to a large degree, we have not previously on that account shied away from applying normal rules of stare decisis when urged to reconsider earlier decisions. Over the past 21 years, for example, the court has overruled in whole or in part 34 of its previous constitutional decisions. The joint opinion picks out and discusses two prior court rulings that it believes are the intensely divisive variety, and concludes that they are of comparable dimension to Roe, discussing Lochner v. New York and Plessy v. Ferguson. It appears to us very odd indeed that the joint opinion chooses as benchmarks two cases in which the court chose not to adhere to erroneous constitutional precedent, but instead enhanced its stature by acknowledging and correcting its error, apparently in violation of the joint opinion's legitimacy principle. One might also wonder how it is that the joint opinion puts these, and not others, in the intensely divisive category, and how it assumes that these are the only two lines of cases of comparable dimension to Roe. There is no reason to think that either Plessy or Lochner produced the sort of public protest when they were decided that Roe did. There were undoubtedly large segments of the bench and bar who agreed with the dissent's view that agreed with the dissenting views in those cases. But surely that cannot be what the court means when it uses the term intensely divisive, or many other cases would have to be added to the list. In terms of public protest, however, Roe, so far as we know, was unique. But just as the court should not respond to that sort of protest by retreating from the decision simply to allay the concerns of the protesters, it should likewise not respond to determining to adhere to the decisions at all costs, lest it seem to be retreating under fire. Public protest should not alter the normal application of stare decisis, lest perfectly lawful protest activity be penalized by the court itself. Taking the joint opinion on its own terms, we doubt that its distinction between Roe on one hand and Plessy and Lochner on the other withstands analysis. The joint opinion acknowledges that the court improves its stature by overruling Plessy and Brown on a deeply divisive issue, and our decisions in West Coast Hotel, which overruled Atkins v. Children's Hospital, and Lochner, was rendered at a time when Congress was considering President Franklin Roosevelt's proposal to reorganize this court and enable him to name 6 additional justices in the event that any member of the court over the age of 70 did not elect to retire. It is difficult to imagine a situation in which the court would face more intense opposition to a prior ruling than it did at the time, and under the general principle proclaimed in the joint opinion, the court seemingly should have responded to this opposition by stubbornly refusing to re-examine the Lochner rationale, lest it lose legitimacy by appearing to overrule under fire. The joint opinion agrees that the court's stature would have been seriously damaged if, in Brown and West Coast Hotel, it had dug in its heels and refused to apply normal principles of stare decisis to their earlier decisions. But the opinion contends that the court was entitled to overrule Plessy and Lochner in those cases, despite the existence of opposition to the original decisions, only because both the nation and the court had learned new lessons in the interim. This is at best a feebly supported post hoc rationalization for those decisions. For example, the opinion asserted that the court could justifiably overrule its decision in Lochner only because the Depression had convinced most people that constitutional protection for contractual freedom contributed to an economy that failed to protect the welfare of all. Surely the joint opinion does not mean to suggest that people saw this court's failure to uphold minimum wage statutes as the cause of the Great Depression. In any event, the Lochner court did not base its rule upon the policy judgment that an unregulated market was fundamental to a stable economy. It simply believed, erroneously, that liberty under the Due Process Clause protected the right to make a contract. Nor is it the case that the people of this nation only discovered the dangers of extreme laissez-faire economics because of the Depression. State laws regulating maximum hours and minimum wages were in existence well before that time. A Utah statute of that sort, enacted in 1896, was involved in our decision in Holden v. Hardy, and other states followed suit shortly afterwards, Mueller v. Oregon and Bunting v. Oregon. These statutes were indeed enacted because of a belief not on the part of their sponsors that freedom of contract did not protect the welfare of workers, demonstrating that belief manifested itself more than a generation before the Great Depression. Whether most people had come to share it in the hard times of the 1930s is, insofar as anything the joint opinion advances, entirely speculative. The crucial failing at that time was not that workers were not paid a fair wage, but that there was no work available at any wage. When the court finally recognized its error in West Coast Hotel, it did not engage in a post hoc rationalization that the joint opinion attributes to it today. It did not state that Lochner had been based on an economic view that had fallen into disfavor, and that it therefore should be overruled. Chief Justice Hughes, in his opinion for the court, simply recognized what Justice Holmes had previously recognized in his Lochner dissent, that the Constitution does not speak of freedom of contract. Quoting Lochner v. New York in dissent, a constitution is not intended to embody a particular economic theory, whether of paternalism and the organic relation of the citizen to the state, or of laissez-faire. Although the court did acknowledge in the last paragraph of its opinion the state of affairs during the then current Depression, the theme of the opinion is that the court had been mistaken as a matter of constitutional law when it embraced freedom of contract 32 years previously. The joint opinion also agrees that the court acted properly in rejecting the doctrine of separate but equal in Brown. In fact, the opinion lauds Brown in comparing it to Roe. This is strange in that under the opinion's legitimacy principle, the court would seemingly have been forced to adhere to its erroneously decision in Plessy because of its intensely divisive character. To us, adherence to Roe today, under the guise of legitimacy, would seem to resemble more closely adherence to Plessy on the same ground. Fortunately, the court did not choose that option in Brown, and instead frankly repudiated Plessy. The joint opinion concludes that such repudiation was justified only because of newly discovered evidence that segregation had the effect of treating one race as inferior to another. But it can hardly be argued that this was not urged upon those who decided Plessy. As Justice Harlan observed in his dissent, that the law at issue puts a brand of servitude and degradation upon a large class of our fellow citizens, our equals before the law. It is clear that the same arguments made before the court in Brown were made in Plessy as well. The court in Brown simply recognized, as Justice Harlan had recognized beforehand, that the 14th Amendment does not permit racial segregation. The rule of Brown is not tied to popular opinion about the evils of segregation. It is a judgment that the Equal Protection Clause does not permit racial segregation, no matter whether the public might come to believe that it is beneficial. On that ground it stands, and on that ground alone, the court was justified in properly concluding that the Plessy court had erred. There is also a suggestion in the joint opinion that the propriety of overruling a divisive decision depends in part on whether most people would now agree that it should be overruled. Either the demise of opposition or its progression to substantial popular agreement apparently is required to allow the court to reconsider a divisive decision. How such agreement would be ascertained, short of a public opinion poll, the joint opinion does not say. But surely even the suggestion is totally at war with the idea of legitimacy, in whose name it is invoked. The judicial branch derives its legitimacy not from following public opinion, but from deciding by its best lights whether the legislative enactments of the popular branches of government comport with the Constitution. The doctrine of stare decisis is an adjunct of this duty, and should be no more subject to the vagaries of public opinion than is the basic judicial task. There are other reasons why the joint opinion's discussion of legitimacy is unconvincing as well. In assuming that the court is perceived as surrendering to political pressure when it overrules a controversial decision, the joint opinion forgets that there are two sides to any controversy. The joint opinion asserts that, in order to protect its legitimacy, the court must refrain from overruling a controversial decision lest it be viewed as favoring those who oppose the decision. But his decision to adhere to prior precedent is subject to the same criticism. For in such a case, one can easily argue that the court is responding to those who have demonstrated in favor of the original decision. The decision in Roe has engendered large demonstrations, including repeated marches on this court and on Congress, both in opposition to and in support of that opinion. A decision either way on Roe can therefore be perceived as favoring one group or the other. But this perceived dilemma arises only if one assumes, as the joint opinion does, that the court should make its decision with a view towards speculative public perceptions. If one assumes instead, as the court surely did in both Brown and West Coast Hotel, that the court's legitimacy is enhanced by a faithful interpretation of the Constitution irrespective of public opposition, such self-engendered difficulties may be put to one side. Roe is not this court's only decision to generate conflict. Our decisions in some recent capital cases and in Bowers v. Hardwick have also engendered demonstrations in opposition. The joint opinion's message to such protesters appears to be that they must cease their activities in order to serve their cause, because their protests will only cement in place a decision which by normal standards of stare decisis should be reconsidered. Nearly a century ago, Justice David J. Brewer of this court, in an article discussing criticism of its decisions, observed that many criticisms may be, like their authors, devoid of good taste, but better all sorts of criticism than no criticism at all. This was good advice to the court then, as it is today. Strong and often misguided criticism of a decision should not render the decision immune from reconsideration, lest a fetish for legitimacy penalize freedom of expression. The end result of the joint opinion's paeans of praise for legitimacy is the enunciation of a brand new standard for evaluating state regulation of a woman's right to abortion, the undue burden standard. As indicated above, Roe v. Wade adopted a fundamental right standard under which state regulations could survive only if they met the requirement of strict scrutiny. While we disagree with that standard, it at least had a recognized basis in constitutional law at the time Roe was decided. The same cannot be said for the undue burden standard, which is created largely out of whole cloth by the authors of the joint opinion. It is a standard which even today does not command the support of a majority of this court, as it will not, we believe, result in the sort of simple limitation easily applied which the joint opinion anticipates. In sum, it is a standard which is not built to last. In evaluating abortion regulations under that standard, judges will have to decide whether they place a substantial obstacle in the path of a woman seeking an abortion. In that this standard is based even more on a judge's subjective determinations than was the trimester framework, the standard will do nothing to prevent judges from roaming at large in the constitutional field, guided only by their personal views. Because the undue burden standard is plucked from nowhere, the question of what is a substantial obstacle to abortion will undoubtedly engender a variety of conflicting views. For example, in the very matter before us now, the authors of the joint opinion would uphold Pennsylvania's 24-hour waiting period, concluding that a particular burden on some women is not a substantial obstacle. But the authors would at the same time strike down Pennsylvania's spousal notice provision after finding that in a large fraction of cases the provision will be a substantial obstacle, and while the authors conclude that the informed consent provisions do not constitute an undue burden, would hold that they do. Furthermore, while striking down the spousal notice regulation, the joint opinion would uphold a parental consent restriction that certainly places very substantial obstacles in the path of a minor's abortion choice. The joint opinion is forthright in admitting that it draws this distinction based on a policy judgment that parents will have the best interests of their child at heart, while the same is not necessarily true of husbands as to their wives. This may or may not be a correct judgment, but it is quintessentially a legislative one. The undue burden inquiry does not in any way supply the distinction between parental consent and spousal consent, which the joint opinion adopts. Despite the efforts of the joint opinion, the undue burden standard presents nothing more workable than the trimester framework which it discards today. Under the guise of the Constitution, this court will still impart its own preferences on the states in the form of a complex abortion code. The sum of the joint opinions labors in the name of stare decisis and legitimacy is this: Roe v. Wade stands as a sort of judicial Potemkin village, which may be pointed out to passers-by as a monument to the importance of adhering to precedent. But behind the facade, an entirely new method of analysis, without any roots in constitutional law, is imported to decide the constitutionality of state laws regulating abortion. Neither stare decisis nor legitimacy are truly served by such an effort. We have stated above our belief that the Constitution does not subject state abortion regulations to heightened scrutiny. Accordingly, we think that the correct analysis is that set forth by the plurality opinion in Webster. A woman's interest in having an abortion is a form of liberty protected by the Due Process Clause, but states may regulate abortion procedures in ways rationally related to a legitimate state interest. With this rule in mind, we examine each of the challenged provisions. Section 3205 of the Act imposes certain requirements related to the informed consent of a woman seeking an abortion. Section 3205A1 requires that the referring or performing physician must inform a woman contemplating an abortion of 1. The nature of the procedure and the risks and alternatives that a reasonable patient would find material, 2. The fetus's probable gestational age, and 3. The medical risks involved in carrying her pregnancy to term. Section 3205A2 requires a physician or a non-physician counselor to inform the woman that 1. The state health department publishes free materials describing the fetus at different stages and listing abortion alternatives. 2. Medical assistance benefits may be available for prenatal childbirth, and neonatal care. And 3. The child's father is liable for child support. The Act also imposes a 24-hour waiting period between the time that the woman receives the required information and the time that the physician is allowed to perform the abortion. The court has held that it is certainly within the province of the states to require a woman's voluntary and informed consent to an abortion. Here, Pennsylvania seeks to further its legitimate interest in obtaining informed consent by ensuring that each woman is aware not only of the reasons for having an abortion, but also of the risks associated with an abortion and the availability of assistance that might make the alternative for normal childbirth more attractive than it might otherwise appear. We conclude that this provision of the statute is rationally related to the state's interest in assuring that a woman's consent to an abortion be a fully informed decision. Section 3205A1 requires a physician to disclose certain information about the abortion procedure and its risks and alternatives. This requirement is certainly no large burden, as the Court of Appeals found that the record shows that the clinics, without exception, insist on providing this information to women before an abortion is performed. We are of the view that this information clearly is related to maternal health and to the state's legitimate purpose in requiring informed consent. An accurate description of the gestational age of the fetus and of the risks involved in carrying a child to term helps to further both those interests and the state's legitimate interest in unborn human life. Although petitioners contend that it is unreasonable for the state to require that a physician, as opposed to a non-physician counselor, disclose this information, we agree with the Court of Appeals that a state may rationally decide that physicians are better qualified than counselors to impart this information and answer questions about the medical aspects of the available alternatives. Section 3205A2 compels the disclosure by a physician or a counselor of information concerning the availability of paternal child support and state-funded alternatives if the woman decides to proceed with her pregnancy. Here again, the Court of Appeals observed that the record indicates that most clinics already require that a counselor consult in person with the woman about alternatives to abortion before the abortion is performed. The petitioners do not claim that the information required to be disclosed by statute is in any way false or inaccurate. Indeed, the Court of Appeals found it to be relevant, accurate, and non-inflammatory. We conclude that this required presentation of balanced information is rationally related to the state's legitimate interest in ensuring that the woman's consent is truly informed, and in addition furthers the state's interest in preserving unborn life. That the information might create some uncertainty and persuade some women to forego abortions does not lead to the conclusion that the Constitution forbids the provision of such information. Indeed, it only demonstrates that this information might very well make a difference, and that it is therefore relevant to a woman's informed choice. Quoting Justice White dissenting, the ostensible objective of Roe v. Wade is not maximizing the number of abortions, but maximizing choice. We acknowledge that in Thornburg, this court struck down informed consent requirements similar to the ones at issue here. It is clear, however, that while the detailed framework of Roe held to the court's invalidation of those informational requirements, they would have been sustained under any traditional standard of judicial review, or for any other surgical procedure except abortion. Quoting Webster v. Reproductive Health Services and the plurality opinion, citing Thornburg versus American Obstetrician Gynecologists, White dissenting, and the quoting Berger dissenting, in light of our rejection of Roe's fundamental right approach, in the light of our rejection of Roe's fundamental right approach to this subject, we do not regard Thornburg as controlling. For the same reason, we do not feel bound to follow this court's previous holding that a state's 24-hour mandatory waiting period is unconstitutional. Petitioners are correct that such a provision will result in delays for some women that might not otherwise exist, therefore placing a burden on their liberty. But the provision in no way prohibits actions, and the informed consent and waiting period requirements do not apply in the case of a medical emergency. We are of the view that in providing time for reflection and reconsideration, the waiting period helps ensure that a woman's decision to abort is a well-considered one, and reasonably furthers the state's legitimate interest in maternal health and in the unborn life of the fetus. It is surely a small cost to impose to ensure that the woman's decision is well considered in light of its certain and irreparable consequences of fetal life, and the possible effects on her own. In addition to providing her own informed consent before an unemancipated woman under the age of 18 may obtain an abortion, she must either furnish the consent of one of her parents or must opt for the judicial procedure that allows her to bypass the consent requirement. Under the judicial bypass option, a minor can obtain an abortion if a state court finds that she is capable of giving her informed consent and has indeed given such consent, or determines that an abortion is in her best interests. Records of these court proceedings are kept confidential. The Act directs the state trial court to render a decision within 3 days of the woman's application, and the entire procedure, including appeal to Pennsylvania Superior Court, is to last no longer than 8 business days. The parental consent requirement does not apply in the case of a medical emergency. The provision is entirely consistent with this court's previous decisions involving parental consent requirements. See Planned Parenthood Association of Kansas City, Missouri versus Ashcroft, upholding parental consent requirements with a similar judicial bypass option, Akron versus Akron Center for Reproductive Health, approving of parental consent statutes that include a judicial bypass option allowing a pregnant minor to demonstrate that she is sufficiently mature to make the abortion decision herself, or that, despite her immaturity, an abortion would be in her best interests. We think it beyond dispute that a state has a strong and legitimate interest in the welfare of its young citizens whose immaturity, inexperience, and lack of judgment may sometimes impair their ability to exercise their rights wisely. A requirement of parental consent to abortion, like myriad other restrictions placed upon minors in other contexts, is reasonably designed to further this important and legitimate state interest. In our view, it is entirely rational and fair for the state to conclude that in most instances, the family will strive to give a lonely or even terrified minor advice that is both compassionate and mature. Quoting let's see, Ohio versus Akron Center for Reproductive Health. See also Planned Parenthood of Central Missouri v. Danforth, quoting Justice Stewart, concurring, there can be little doubt that the state furthers a constitutionally permissible end by encouraging an unmarried pregnant minor to seek the help and advice of her parents in making the very important decision whether or not to bear a child. We thus conclude that Pennsylvania's parental consent requirement should be upheld. Section 3209 of the Act contains the spousal notification provision, the requirement that before a physician may perform an abortion on a married woman, the woman must sign a statement indicating that she has notified her husband of her planned abortion. A woman is not required to notify her husband if 1. Her husband is not the father, 2. Her husband, after diligent effort, cannot be located, 3. The pregnancy is the result of a spousal sexual assault and has been reported to the authorities, or 4. The woman has reason to believe that notifying her husband is likely to result in the infliction of bodily harm upon her by him or by another individual. In addition, a woman is exempted from the notification requirement in the case of an emergency. We first emphasize that Pennsylvania has not imposed a spousal consent requirement of the type the court struck down in Planned Parenthood of Central Missouri v. Danforth. Missouri's spousal consent provision was invalidated in that case because the courts viewed that it unconstitutionally granted to the husband a veto power exercisable for any reason whatsoever or for no reason at all. But the provision here involves a much less intrusive requirement of spousal notification, not consent. Such a law requiring only notice to the husband does not give any third party the legal right to make the woman's decision for her, or to prevent her from obtaining an abortion should she choose to have one performed. Danforth does not control our analysis. Petitioners contend that it should, however. They argue that the real effect of such a notice requirement is to give the power to husbands to veto a woman's abortion choice. The district court indeed found that the notification provision created a risk that some woman who would otherwise have an abortion will be prevented from having one. For example, petitioners argue, many notified husbands will prevent abortions through physical force, psychological coercion, and other types of threats. But Pennsylvania has incorporated exceptions in the notice provision in an attempt to deal with these problems. For instance, a woman need not notify her husband if the pregnancy is the result of a reported sexual assault, or if she has reason to believe that she would suffer bodily injury as a result of the notification. Furthermore, because this is a facial challenge to the Act, it is insufficient for petitioners to show that the notification provision might operate unconstitutionally under some conceivable set of circumstances. Thus, it is not enough for petitioners to show that in some worst-case circumstances, the notice provision will operate as a grant of veto power to husbands. Because they are making a facial challenge to the provision, they must show that no set of circumstances exist under which the provision would be valid. This they failed to do. The question before us is therefore whether the spousal notification requirement rationally furthers any legitimate state interests. We conclude that it does. First, a husband's interest in procreation within marriage and in the potential life of his unborn child are certainly substantial ones. See Planned Parenthood of Central Missouri v. Danforth. We are not unaware of the deep and proper concern and interest that a devoted and protective husband has in his wife's pregnancy and in the growth of development of the fetus she is carrying. The state itself has legitimate interests both in protecting these interests of the father and in protecting the potential life of the fetus, and the spousal notification requirement is reasonably related to advancing those state interests. By providing that a husband will usually know of his spouse's intent to have an abortion, the provision makes it more likely that the husband will participate in deciding the fate of his unborn child, a possibility that might otherwise have been denied him. This participation might in some cases result in a decision to proceed with the pregnancy. As Judge Alito observed, in his dissent below, the Pennsylvania legislature could have rationally believed that As Judge Alito observed in his dissent below, the Pennsylvania legislature could have rationally believed that some married women are initially inclined to obtain an abortion without their husband's knowledge because of perceived problems, such as economic constraints, future plans, or the husband's previously expressed opposition, that may be obviated by discussion prior to the abortion. The state also has a legitimate interest in promoting the integrity of the marital relationship. This court has previously recognized the importance of the marital relationship in our society. In our view, the spousal notification requirement is a rational attempt by the state to improve truthful communication between spouses and encourage collaborative decision-making and thereby fostering marital integrity. See Labine versus Vincent. The power to make rules to establish, protect, and strengthen family life is committed to the state legislatures. Petitioners argue that the notification requirement does not further any such interest. They assert that the majority of wives already notify their husbands of their abortion decisions, and the remainder have excellent reasons for keeping their decisions a secret. In the first case, they argue, the law is unnecessary, and in the second case, it will only serve to foster marital discord and threats of harm. Thus, petitioners see the law as a totally irrational means of furthering whatever legitimate interest the state may have. But in our view, it is unrealistic to assume that every husband-wife relationship is either 1, so perfect that this type of truthful and important communication will take place as a matter of course, or 2, so imperfect that upon notice the husband will react selfishly, violently, or contrary to the best interests of his wife. The spousal notice provision will admittedly be unnecessary in some circumstances and possibly harmful in others, but the existence of particular cases in which a feature of a statute performs no function or is even counterproductive ordinarily does not render the statute unconstitutional or even constitutionally suspect. The Pennsylvania legislature was in a position to weigh the likely benefits of the provision against its likely adverse effects, and presumably concluded on balance that the provision would be beneficial. Whether this was a wise decision or not, we cannot say that it was irrational. We therefore conclude that the spousal notice provision comports with the Constitution. See Harris v. McCrae. It is not the mission of this court or any other to decide whether the balance of competing interests is wise social policy. The Act also imposes various reporting requirements. Section 3214A requires that abortion facilities file a report on each abortion performed. The reports do not include the identity of the women on whom abortions are performed, but they do contain a variety of information about the abortions. For example, each report must include the identities of the performing and referring physicians, the gestational age of the fetus at the time of abortion, and the basis for any medical judgment that a medical emergency existed. The district court found that these reports are kept completely confidential. We further conclude that these reporting requirements rationally further the state's legitimate interest in advancing the state of medical knowledge concerning maternal health and prenatal health, in gathering statistical information with respect to patients, and in ensuring compliance with other provisions of the Act. Section 3207 of the Act requires each abortion facility to file a report with its name and address, as well as the names and addresses of any parent, subsidiary, or affiliated organizations. Section 3214F further requires each facility to file quarterly reports stating the total number of abortions performed, broken down by trimester. Both of these reports are available to the public only if the facility received state funds within the preceding 12 months. Petitioners do not challenge the requirement that facilities provide this information. They contend, however, that the forced public disclosure of the information given by facilities receiving public funds serves no legitimate state interest. We disagree. Records relating to the expenditure of public funds are generally available to the public under Pennsylvania law. As the Court of Appeals observed, when a state provides money to a private commercial enterprise, there is a legitimate public interest in informing taxpayers who the funds are benefiting and what services the funds are supporting. These reporting requirements rationally further this legitimate state interest. Finally, petitioners challenge the medical emergency exception provided by the Act. The existence of a medical emergency exempts compliance with the Act informed consent, parental consent, and spousal notice requirements. The Act defines a medical emergency as that condition which, on the basis of the physician's good faith clinical judgment, so complicates the medical condition of a pregnant woman as to necessitate the immediate abortion of her pregnancy to avert her death, or for which a delay will create serious risk of substantial and irreversible impairment of major bodily function. Petitioners argued before the district court that the statutory definition was inadequate because it did not cover three serious conditions that pregnant women can suffer: preeclampsia, inevitable abortion, and prematurely ruptured membrane. The district court agreed with petitioners that the medical emergency exception was inadequate, but the Court of Appeals reversed this holding. In construing the medical exception provision, the Court of Appeals first observed that all three conditions do indeed present the risk of serious injury or death when an abortion is not performed, and noted that the medical professions uniformly prescribed treatment for each of the three conditions is an immediate abortion. Finding that the Pennsylvania legislature did not choose the wording of its medical emergency exception in a vacuum, the court read the exception as intended, to assure that compliance with its abortion regulations would not in any way pose a significant threat to the life or health of a woman. It thus concluded that the exception encompassed each of the three dangerous conditions pointed to by petitioners. We observe that Pennsylvania's present definition of medical emergency is almost an exact copy of that state's definition at the time of this court's ruling in Thornburg, one which the court made reference to with apparent approval. It is clear that the Pennsylvania legislature knows how to provide a medical emergency exception when it chooses to do so. We find that the interpretation of the Court of Appeals in these cases was eminently reasonable, and that the provision thus should be upheld. When a woman is faced with any condition that poses a significant threat to her life or health, she is exempted from the Act's consent. She is exempted from the Act's consent and notice requirements and may proceed immediately with her abortion. For the reasons stated, we therefore would hold that each of the challenged provisions of the Pennsylvania statute is consistent with the Constitution. It bears emphasis that our conclusion in this regard does not carry with it any necessary approval of these regulations. Our task is, as always, to decide only whether the challenged provisions of a law comport with the United States Constitution. If, as we believe, these do, their wisdom as a matter of public policy is for the people of Pennsylvania to decide. Justice Scalia, with whom the Chief Justice, Justice White, and Justice Thomas joined concurring in the judgment in part and dissenting in part. My views on this matter are unchanged for those I set forth in my separate opinions in Webster v. Reproductive Health Services and Ohio v. Akron Center for Reproductive Rights. The state may, if they wish, permit abortion on demand, but the Constitution does not require them to do so. The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. As the court acknowledges, where reasonable people disagree, the government can adopt one position or the other. The court is correct in adding the qualification that this assumes a state of affairs in which the choice does not intrude upon a protected liberty. But the crucial part of that qualification is the penultimate word. A state's choice between two positions on which reasonable people can disagree is constitutional even when, as is often the case, it intrudes upon a liberty in the absolute sense. Laws against bigamy, for example, with which societies of reasonable people disagree, intrude upon men and women's liberty to marry and live with one another. But bigamy happens not to be a liberty protected under the Constitution. That is, quite simply, the issue in these cases, not whether the power of a woman to abort her unborn child is a liberty in the absolute sense, or even whether it is a liberty of great importance to many women. Of course, it is both. The issue is whether it is a liberty protected by the Constitution of the United States. I am sure it is not. I reach that conclusion not because of anything so exalted as my views concerning the concept of existence, of meaning, of the universe, and of the mysteries of life. Rather, I reach it for the same reason I reach the conclusion that bigamy is not constitutionally protected, because of two simple facts. The Constitution says nothing about it, and the long-standing traditions of American society have permitted it to be legally proscribed. The court destroys the proposition evidently meant to represent my position, that liberty includes only those practices defined at the most specific level that were protected against government interference by other rules of law when the 14th Amendment was ratified. That is not, however, what Michael H. says. It merely observes that in defining liberty, we may not disregard a specific relevant tradition protecting or denying protection to the asserted right. But the court does not wish to be fettered by any such limitations on its preferences. The court's statement that it is attempting to acknowledge the authoritativeness of tradition in order to curb the discretion of federal judges is, of course, rhetoric rather than reality. No government official is tempted to place restraints upon his own freedom of action, which is why Lord Acton did not say power tends to purify. The court's temptation is in the court's temptation is in the quite opposite and more natural direction, towards systematically eliminating checks upon its own power, and it succumbs. Beyond that brief summary of the essence of my position, I will not swell the United States reports with repetition of what I have said before, and applying the rational basis test. I would uphold the Pennsylvania statute in its entirety. I must, however, respond to a few of the more outrageous arguments in today's opinion, which it is beyond human nature to leave unanswered. I shall discuss each of them under a quotation from the court's opinion to which they pertain. The inescapable fact is that adjudication of substantive due process claims may call upon the court, in interpreting the Constitution, to exercise that same capacity which, by tradition, courts always have exercised, reasoned judgment. Assuming that the question before us is to be resolved at such a level of philosophical abstraction, in such isolation from the traditions of American society, as by simply applying reasoned judgment, I do not see how that could possibly have produced the answer the court arrived at in Roe v. Wade. Today's opinion describes the methodology of Roe quite accurately as weighing against the women's interest the state's important and legitimate interest in protecting the potentiality of human life. But reasoned judgment does not begin by begging the question, as Roe and subsequent cases unquestionably did, by assuming that what the state is protecting is the mere potentiality of human life. The whole argument of abortion opponents is that what the court calls the fetus and what others call the unborn child is a human life. Thus, whatever answer Roe came up with after conducting its balancing is bound to be wrong, unless it is correct that the human fetus is in some critical sense merely potentially human. There is, of course, no way to determine that as a legal matter. It is, in fact, a value judgment. Some societies have considered newborn children not yet human, or the incompetent elderly no longer so. The authors of the joint opinion, of course, do not squarely contend that Roe v. Wade was a correct application of reasoned judgment, merely that it must be followed because of stare decisis. But in their exhaustive discussion of all the factors that go into the determination of when stare decisis should be observed and when disregarded, they never mention how wrong was the decision on its face. Surely, if the court's power lies in its legitimacy, a product of substance and perception, the substance part of the equation demands that plain error be acknowledged and eliminated. Roe was plainly wrong, even on the court's methodology of reasoned judgment, and even more so, of course, if the proper criteria of text and tradition are applied. The emptiness of the reasoned judgment that produced Roe is displayed in plain view by the fact that after more than 19 years of effort by some of the brightest and most determined legal minds in the country, after more than 10 cases upholding abortion rights in this court, and after dozens upon dozens of amicus briefs submitted in these and other cases, the best the court can do to explain how it is that the word liberty must be thought to include the right to destroy human fetuses is to rattle off a collection of adjectives that simply decorate a value judgment and conceal a political choice. The right to abort, we are told, inheres in liberty because it is among a person's most basic decisions. It involves a most intimate and personal choice. It is central to personal dignity and autonomy. It originates within the zone of conscience and belief. It is too intimate and personal for state interference. It reflects intimate views of a deep personal character. It involves intimate relationships and notions of personal autonomy and bodily integrity, and it concerns a particularly important decision. But it is obvious to anyone applying reasoned judgment that the same adjectives can be applied to many forms of conduct that this court, including one of the justices in today's majority, see Bowers v. Hardwick, has held are not entitled to constitutional protection because, like abortion, they are forms of conduct that have long been criminalized in American society. Those adjectives might be applied, for example, to homosexual sodomy, polygamy, adult incest, and suicide, all of which are equally intimate and deeply personal decisions involving personal autonomy and bodily integrity, and all of which can constitutionally be proscribed because it is our unquestionable constitutional tradition that they are proscribable. It is not reasoned judgment that supports the court's decision, only personal predilection. Justice Curtis's warning is as timely today as it was 135 years ago. When a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned, and the theoretical opinions of individuals are allowed to control its meaning, we have no longer a Constitution. We are under the government of individual men, who, for the time being, have power to declare what the Constitution is according to their own views of what it ought to mean, quoting Dred Scott v. Sanford, the dissenting opinion. Liberty finds no refuge in a jurisprudence of doubt. One might have feared to encounter this august and sonorous phrase in an opinion defending the real Roe v. Wade rather than the revised version fabricated today by the authors of the joint opinion. The shortcomings of Roe did not include lack of clarity. Virtually all regulation of abortion before the third trimester was invalid. But to come across this phrase in the joint opinion, which calls upon federal judges to apply an undue burden standard, as doubtful in implication as it is unprincipled in origin, is really more than one should have to bear. The joint opinion frankly concedes that the amorphous concept of undue burden has been inconsistently applied by the members of this court in a few brief years since that test was first explicitly propounded by Justice O'Connor in her dissent in Akron 1. Because the three justices now wish to set forth a standard of general application, the joint opinion announces that it is important to clarify what is meant by undue burden. I certainly agree with that, but I do not agree that the joint opinion succeeds in the announced endeavor. To the contrary, its efforts at clarification make clear only that the standard is inherently manipulable and will prove hopelessly unworkable in practice. The joint opinion explains that a state regulation imposes an undue burden if it has the purpose of effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. An obstacle is substantial, we are told, if it is calculated not to inform the woman's free choice, but to hinder it. This latter statement cannot possibly mean what it says. Any regulation of abortion that is intended to advance what the joint opinion concedes is the state's substantial interest in protecting unborn life will be calculated to hinder a decision to have an abortion. It thus seems more accurate to say that the joint opinion would uphold abortion regulations only if they do not unduly hinder the woman's decision. That, of course, brings us right back to square one. Defining an undue burden as an undue hindrance or a substantial obstacle hardly clarifies the test. Consciously or not, the joint opinion's verbal shell game will conceal raw judicial policy choices concerning what is appropriate abortion legislation. The ultimately standardless nature of the undue burden inquiry is a reflection of the underlying fact that the concept has no principled or coherent legal basis. As the Chief Justice points out, Roe's strict scrutiny standard at least had a recognized basis in constitutional law at the time Roe was decided, while the same cannot be said for the undue burden standard, which is created largely out of whole cloth by the authors of the joint opinion. The joint opinion is flatly wrong in asserting that our jurisprudence relating to all liberties, save perhaps abortion, has recognized the permissibility of laws that do not impose an undue burden. It argues that the abortion right is similar to other rights in that a law not designed to strike at the right itself, but which has the incidental effect of making it more difficult or more expensive to exercise the right is not valid. I agree, indeed I have, forcefully urged, that a law of general applicability which places only an incidental burden on a fundamental right does not infringe that right. But that principle does not establish the quite different and quite dangerous proposition that a law which directly regulates a fundamental right will not be found to violate the Constitution unless it imposes an undue burden. It is that, of course, which is at issue here. Pennsylvania has consciously and directly regulated conduct that our cases have held is constitutionally protected. The appropriate analogy, therefore, is that of a state law requiring purchasers of religious books to endure a 24-hour waiting period or to pay a nominal tax of 1 penny. The 1 cent. The joint opinion cannot possibly be correct in suggesting that we would uphold such legislation on the basis that it does not impose a substantial obstacle to the exercise of First Amendment rights. The undue burden standard is not at all the generally applicable principle the joint opinion pretends it to be. Rather, it is a unique concept created specially for these cases to preserve some judicial foothold in this ill-gotten territory. In claiming otherwise, the three justices showing their willingness to place all constitutional rights at risk in an effort to preserve what they deem to the central holding of Roe. The rootless nature of the undue burden standard, a phrase plucked out of context from our earlier abortion decisions, is further reflected in the fact that the joint opinion finds it necessary expressly to repudiate the more narrow formulations used in Justice O'Connor's earlier opinions. Those opinions stated that a statute imposes an undue burden if it imposes absolute obstacles or severe limitations on the abortion decision. Those strong adjectives are conspicuously missing from the joint opinion, whose authors have for some unexplained reason now determined that a burden is undue if it merely imposes a substantial obstacle to abortion decisions. Justice O'Connor also abandoned, again without explanation, the view she expressed in Planned Parenthood Association of Kansas City, Missouri, Incorporated versus Ashcroft, that a medical regulation which imposes an undue burden could nevertheless be upheld if it reasonably relates to the preservation and protection of maternal health. In today's version, even health measures will be upheld only if they do not constitute an undue burden. Gone too is Justice O'Connor's statement that the state possesses compelling interests in the protection of potential human life throughout pregnancy. Instead, the state's interest in unborn human life is stealthily downgraded to a mere substantial or profound interest. That had to be done, of course, since designating the interest as compelling throughout pregnancy would have been, shall we say, a substantial obstacle to the joint opinion's determined effort to reaffirm what it views as the central holding of Roe. And viability is no longer the arbitrary dividing line previously decried by Justice O'Connor in Akron 1. The court now announces that the attainment of viability may continue to serve as the critical fact. It is difficult to maintain the illusion that we are interpreting a constitution rather than inventing one when we amend its provisions to so breezily. Because the portion of the joint opinion adopting and describing the undue burden test provides no more useful guidance than the empty phrases discussed above, one must turn to the 23 pages applying that standard to the present facts for further guidance. In evaluating Pennsylvania's abortion law, the joint opinion relies extensively on the factual findings of the district court and repeatedly qualifies its conclusions by noting that they are contingent upon the record developed in these cases. Thus, the joint opinion would uphold the 24-hour waiting period contained in the Pennsylvania statute's informed consent provision because the record evidence shows that in the vast majority of cases, a 24-hour delay does not create any appreciable health risk. The three justices therefore conclude that on the record before us, we are not convinced that the 24-hour waiting period constitutes an undue burden. The requirement that a doctor provide the information pertinent to informed consent would also be upheld because there is no evidence on this record that this requirement would amount in practical terms to a substantial obstacle to a woman seeking an abortion. Similarly, the joint opinion would uphold the reporting requirements in the Act, sections 3207 and 3214, because there is no showing on the record before us that these requirements constitute a substantial obstacle to abortion decisions. But at the same time, the opinion pointedly observes that these reporting requirements may increase the costs of abortions and that at some point that fact could become a substantial obstacle. Most significantly, the joint opinion's conclusion that the spousal notice requirement of the Act, see subsection 3209, imposes an undue burden is based in large measure on the district court's detailed findings of fact, which the joint opinion sets out at great length. I do not, of course, have any objection to the notion that, in applying legal principles, one should rely only upon the facts that are contained in the record, or that are properly subject to judicial notice. But what is remarkable about the joint opinion's fact-intensive analysis is that it does not result in any measurable clarification of the undue burden standard. Rather, the approach for the Rather, the approach of the joint opinion is, for the most part, simply to highlight certain facts in the record that apparently strike the three justices as particularly significant in establishing or refuting the existence of an undue burden. After describing these facts, the opinion then simply announces that the provision either does or does not impose a substantial obstacle or an undue burden. We do not know whether the same conclusions could have been reached on a different record, or in what respects the record would have had to differ before an opposite conclusion would have been appropriate. The inherently standardless nature of this inquiry invites the district judge to give effect to his personal preferences about abortion. By finding and relying upon the right facts, he can invalidate, it would seem, almost any abortion restriction that strikes him as undue, subject, of course, to the possibility of being reversed by a court of appeals or Supreme Court that is as unconstrained in reviewing his decision as he was in making it. To the extent I can discern any meaningful content in the undue burden standard as applied in the joint opinion, it appears to be that a state may not regulate abortion in such a way as to reduce significantly its incidence. The joint opinion repeatedly emphasizes that an important factor in the undue burden analysis is whether the regulation prevents a significant number of women from obtaining an abortion, whether a significant number of women are likely to be deterred from procuring an abortion, and whether the regulation often deters women from seeking abortions. We are not told, however, what forms of deterrence are impermissible or what degree of success in deterrence is too much to be tolerated. If, for example, a state required a woman to read a pamphlet describing with illustrations the facts of fetal development before she could obtain an abortion, the effect of such legislation might be to deter a significant number of women from procuring abortions, thereby seemingly allowing a district judge to invalidate it as an undue burden. Thus, despite flowery rhetoric about the state's substantial and profound interest in potential human life and criticism of Roe for undervaluing that interest, the joint opinion permits the state to pursue that interest only so long as it is not too successful. As Justice Blackmun recognizes with evident hope, the undue burden standard may ultimately require the invalidation of each provision upheld today if it can be shown on a better record that the state is too effectively expressing a preference for childbirth over abortion. Reason finds no refuge in this jurisprudence of confusion. While we appreciate the weight of the arguments that Roe should be overruled, the reservations any of us have in reaffirming the central holding of Roe are outweighed by the explication of individual liberty we have given combined with the force of stare decisis. Let me read that again. While we appreciate the weight of the arguments that Roe should be overruled, the reservations any of us may have in reaffirming the central holding of Roe are outweighed by the explication of individual liberty we have given combined with the force of stare decisis. The court's reliance upon stare decisis can best be described as contrived. It insists upon the necessity of adhering not to all of Roe, but only to what it calls the central holding. It seems to me that stare decisis ought to be applied even to the doctrine of stare decisis, and I confess never to have heard of this new keep what you want and throw away the rest version. I wonder whether, as applied to Marbury v. Madison, for example, the new version of stare decisis would be satisfied if we allowed courts to review the constitutionality of only those statutes that, like the one in Marbury, pertain to the jurisdiction of the courts. I am certainly not in a good position to dispute that the court has saved the central holding of Roe, since to do that effectively, I would have to know what the court has saved, which in turn would require me to understand, as I do not, what the undue burden test means. I must confess, however, that I have always thought and I think a lot of other people have always thought that the arbitrary trimester framework which the court discards today was quite as central to Roe as the arbitrary viability test, which the court today retains. It seems particularly ungrateful to carve the trimester framework out of the core of Roe, since its very rigidity, in sharp contrast to the utter indeterminability of the undue burden test, is probably the only reason the court is able to say, in urging stare decisis, that Roe has in no sense proven unworkable. I suppose the court is entitling is entitled to call a central holding whatever it wants to call a central holding, which is, come to think of it, perhaps one of the difficulties with this modified version of stare decisis. I thought I might note, however, that the following portions of Roe have not been saved. Under Roe, requiring that a woman seeking an abortion be provided truthful information about abortion before giving informed written consent is unconstitutional if the information is designed to influence her choice. Under the joint opinions undue burden regime, as applied today at least, such a requirement is constitutional. Under Roe, requiring that information be provided by a doctor rather than by non-physician counselors is unconstitutional. Under the undue burden regime, as applied today at least, it is not. Under Roe, requiring a 24-hour waiting period between the time the woman gives her informed consent and the time of the abortion is unconstitutional. Under the undue burden regime, as applied today at least, it is not. Under Roe, requiring detailed reports that include demographic data about each woman who seeks an abortion and various information about each abortion is unconstitutional. Under the undue burden regime, as applied today at least, it generally is not. Where in the performance of its judicial duties the court decides a case in such a way as to resolve the sort of intensely divisive controversy reflected in Roe. Its decision has a dimension that the resolution of the normal case does not carry. It is the dimension present whenever the court's interpretation of the Constitution calls the contending sides of a national controversy to end their national division by accepting a common mandate rooted in the Constitution. The court's description of the place of Roe in the social history of the United States is unrecognizable. Not only did Roe not, as the court suggests, resolve the deeply divisive issue of abortion, it did more than anything else to nourish it by elevating it to the national level where it is infinitely more difficult to resolve. National politics were not plagued by abortion protesters, national abortion lobbying, or abortion marches on Congress before Roe v. Wade was decided. Profound disagreement existed among our citizens over the issue, as it does over other issues, such as the death penalty, but that disagreement was being worked out at the state level. As with many other issues, the division of sentiment within each state was not as closely balanced as it was among the population of the nation as a whole, meaning that not only that more people would be satisfied with the results of state-by-state resolution, but also that those results would be more stable. Pre-Roe, moreover, political compromise was possible. Roe's mandate for abortion on demand destroyed the compromise of the past, rendered compromise impossible for the future, and required the entire issue to be resolved uniformly at the national level. At the same time, Roe created a vast new class of abortion consumers and abortion proponents by eliminating the moral opprobrium that had attached to the act. If the Constitution guarantees abortion, how can it be bad? Not an accurate line of thought, but a natural one. Many favor all of those developments, and it is not for me to say that they are wrong. But to portray Roe as the statesman-like settlement of a divisive issue, a jurisprudential piece of Westphalia that is worth preserving, is nothing less than Orwellian. Roe fanned into life an issue that has inflamed our national politics in general and has obscured with its smoke and selection of justices to this court in particular ever since. And by keeping us in the abortion umpiring business, it is the perpetuation of that disruption rather than of any pax Roena that the court's new majority decrees. To overrule under fire would subvert the court's legitimacy. To all those who will be tested by following, the court implicitly undertakes to remain steadfast. The promise of constancy, once given, binds its maker for as long as the power to stand by the decision survives, and the commitment is not obsolete. The American people's belief in themselves as a people who aspire to live according to the rule of law is not readily separable from their understanding of the court invested with the authority to decide their constitutional cases and speak before all others for their constitutional ideals. If the court's legitimacy should be undermined, then so would the country be in its very ability to see itself through its constitutional ideals. The imperial judiciary lives. It is instructive to compare this Nietzschean vision of us unelected, life-tenured judges leading a Volk who will be tested by following and whose very belief in themselves is mystically bound up in their understanding of a court that speaks before all others for their constitutional ideals, with the somewhat more modest role envisioned for these lawyers by the founders. The judiciary has no direction either of the strength or of the wealth of the society and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment. Quoting Federalist 78, or again, to compare this ecstasy of a Supreme Court in which there is, especially on controversial matters, no shadow of change or hint of alteration. There is a limit to the amount of error that can plausibly be imputed to prior courts, with the more democratic views of a more humble man. The candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. Now, quoting Abraham Lincoln in the first inaugural address, it is particularly difficult in the circumstances of the present decision to sit still for the court's lengthy lecture upon the virtues of constancy, of remaining steadfast and adhering to principle. Among the 5 justices who purportedly adhered to Roe, at most 3 agree upon the principle that constitutes adherence, the joint opinion's undue burden standard, and that principle is inconsistent with Roe. To make matters worse, 2 of the 3, in order thus to remain steadfast, had to abandon previously stated positions. It is beyond me how the court expects these accommodations to be accepted as grounded truly in principle, not as compromises with social and political pressures having, as such, no bearing on the principled choices that the court is obliged to make. The only principle the court adheres to, it seems to me, is the principle that the court must be seen as standing by Roe. That is not a principle of law, which is what I thought the court was talking about, but a principle of realpolitik, and a wrong one at that. I cannot agree with, indeed I am appalled by, the court's suggestion that the decision whether to stand by an erroneous constitutional decision must be strongly influenced, against overruling no less, by the substantial and continuing public opposition the decision has generated. The court's judgment that any other course would subvert the court's legitimacy must be another consequence of reading the error-filled history book that describes the deeply divided country brought together by Roe. In my history book, the court was covered with dishonor and deprived of legitimacy by Dred Scott v. Sanford, an erroneous and widely opposed opinion that it did not abandon rather than by West Coast Hotel v. Parrish, which produces the famous switch in time from the court's erroneous and widely opposed constitutional opposition to the social measures of the New Deal. Both Dred Scott and one line of the cases resisting the New Deal rested upon the concept of substantive due process that the court praises and employs today. Indeed, Dred Scott was very possibly the first application of substantive due process in the Supreme Court, the original precedent for Lochner v. New York and Roe v. Wade. But whether it would subvert the court's legitimacy or not, the notion that we would decide a case differently from the way we otherwise would have in order to show that we can stand firm against public disapproval is frightening. It is a bad enough idea, even in the head of someone like me, who believes that the text of the Constitution and our traditions say what they say and there is no fiddling with them. But when it is in the mind of a court that believes the Constitution has an evolving meaning, that the Ninth Amendment refers to other rights is not a disclaimer but a charter for action, and that the function of this court is to speak before all others for the people's constitutional ideals, unrestrained by meaningful text or tradition, then the notion that the court must adhere to a decision for as long as the decision faces great opposition and the court is under fire acquires a character of almost czarist arrogance. We are offended by these marchers who descend upon us every year on the anniversary of Roe to protest our saying that the Constitution requires what our society has never thought the Constitution requires. These people who refuse to be tested by following must be taught a lesson. We have no Cossacks, but at least we can stubbornly refuse to abandon an erroneous opinion that we might otherwise change, to show how little they intimidate us. Of course, the Chief Justice points out we have been subjected to what the court calls political pressure by both sides of this issue. Maybe today's decision not to overrule Roe will be seen as buckling to pressure from that direction. Instead of engaging in the hopeless task of predicting public perception, a job not for lawyers but for political campaign managers, the justices should do what is legally right by asking two questions. Was Roe correctly decided? And has Roe succeeded in producing a settled body of law? If the answer to both questions is no, Roe should undoubtedly be overruled. In truth, I am as distressed as the court is, and expressed my distress several years ago in Webster. About the political pressure directed to the court, the marches, the mail, the protests aimed at inducing us to change our opinions. How upsetting it is that so many of our citizens, good people, not lawless ones, on both sides of this abortion issue, and on various sides of other issues as well, think that we justices should properly take into account their views, as though we were engaged not in ascertaining an objective law, but in determining some kind of social consensus. The court would profit, I think, from giving less attention to the fact of this distressing phenomenon, and more attention to the cause of it. That cause permeates today's opinion. A new mode of constitutional adjudication that relies not upon text and traditional practice to determine the law, but upon what the court calls reasoned judgment, which turns out to be nothing but philosophical predilection and moral intuition. All manner of liberties, the court tells us, inherent in the Constitution and are enforceable by this court, not just those mentioned in the text or established in the traditions of our society. Why even the Ninth Amendment, which says only that the enumeration in the Constitution of certain rights should not be construed to deny or disparage other rights, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, is, despite our contrary understanding for almost 200 years, a literally boundless source of additional unnamed, unhinted at rights, definable and enforceable by us through reasoned judgment. What makes all this relevant to the bothersome application of political pressure against the court are the twin facts that the American people love democracy and the American people are not fools. As long as this court thought and the people thought that we justices were doing essentially lawyers' work up here, reading text and discerning our society's traditional understanding of that text, the public pretty much left us alone. Texts and traditions are facts to study, not convictions to demonstrate about. But if in reality our process of constitutional adjudication consists primarily of making value judgments, if we can ignore a long and clear tradition clarifying an ambiguous text, as we did, for example, 5 days ago in declaring unconstitutional invocations and benedictions at public high school graduation ceremonies. Let me back up. If we can ignore a long and clear tradition of clarifying an ambiguous text, as we did, for example, 5 days ago, in declaring unconstitutional invocations and benedictions at public high school graduation ceremonies. If, as I say, our pronouncement of constitutional law rests primarily on value judgments, then a free and intelligent people's attitude towards us can be expected to be, ought to be, quite different. The people know that their value judgments are quite as good as those taught in any law school, maybe better. If indeed the liberties protected by the Constitution are, as the court says, undefined and unbounded, then the people should demonstrate to protest that we do not implement their values instead of ours. Not only that, but confirmation hearings for new justices should deteriorate into question and answer sessions in which senators go through a list of their constituents' most favored and most disfavored alleged constitutional rights and seek the nominee's commitment to support or oppose them. Value judgments, after all, should be voted on, not dictated. And if our Constitution has somehow accidentally committed them to the Supreme Court, at least we can have a sort of plebiscite each time a new nominee to that body is put forward. Justice Blackmun not only regards this prospect with equanimity, he solicits it. There is a poignant aspect to today's opinion. Its length and what might be called its epic tone suggests that its authors believe they are bringing to an end a troublesome era in the history of our nation and of the court. It is the dimension of authority, they say, to call the contending sides of national controversy to end their national division by accepting a common mandate rooted in the Constitution. There comes vividly to mind a portrait of Emmanuel Lutz, that hangs in the Harvard Law School. Roger Brooke Tawney painted in 1859, the 82-day year of his life, the 24th of his chief justiceship, the second after his opinion in Dred Scott. He is all in black, sitting in a shadowed red armchair, left hand resting upon a pad of paper in his lap, right hand hanging limply, almost lifelessly, beside the inner arm of the chair. He sits facing the viewer and staring straight out. There seems to be on his face and in his deep-set eyes an expression of profound sadness and disillusionment. Perhaps he always looked that way, even when dwelling upon the happiest of thoughts. But those of us who know how the lustre of his great chief justiceship came to be eclipsed by Dred Scott cannot help believing that he had that case. It's already apparent the consequences for the court and its soon to be played out consequences for the nation, burning on his mind. I expect that 2 years earlier he too had thought himself calling the contending sides of national controversy to end their national division by accepting a common mandate rooted in the Constitution. It is no more realistic for us in this litigation than it was for him in that. To think that an issue of the sort they both involved, an issue involving life and death, freedom and subjugation, can be speedily and finally settled by the Supreme Court, as President James Buchanan, in his inaugural address, said the issue of slavery in the territories would be. Quite to the contrary, by foreclosing all democratic outlet for the deep passions this issue arouses, by banishing the issue from the political forum that gives all participants, even the losers, the satisfaction of a fair hearing in an honest fight, by continuing the imposition of a rigid national rule instead of allowing for regional differences, the court merely prolongs and intensifies the anguish. We should get out of this area where we have no right to be and where we do not neither ourselves nor the country any good by remaining. Well, that was a good read. And as always, if there's any case you'd like me to read, just drop in the comments and we're happy to take a look. Thank you.